Hey, thank you. Thanks a lot for the invitation. Before I start, I have to start with two apologies, so to speak, and both will drop a little bit of a bombshell. The first bomb, was dropped actually not by me, but on me, more or less. It was dropped on Frankfurt, and it meant that I was part of a big evacuation process on Sunday, which prevented me from being here yesterday, which I would have otherwise quite liked to do. It was an interesting thing, though, to observe. That's a bomb. They finally dismantled it, but it involved the evacuation of 60,000 people from the Frankfurt city center, rerouting of trains, interruption of waterworks, all done within 3 days warning, essentially. And the reason that was possible is, of course, that there's by now a huge amount of data available of people, where they live, where the access routes are, how streets, waterworks, chemical works are interconnected. So something that would have been a major difficulty even a few years back happened with relatively little disruption for everyone. 60,000 people were moved out starting at 8 o'clock in the morning. 60,000 people moved back in the afternoon, including evacuation of hospitals, including evacuation of police stations, and obviously also quite a bit of environmental concerns, because had this thing exploded, there would have been probably quite a bit of ruptures in water treatment lines, in chemical lines. So all of that had to be coordinated. And that was possible because of big data, because simply of the amount of information we collect about ourselves and distribute to the relevant decision makers. Frankfurt is not a smart city. In the smart city of the future, this is going to be even more pronounced, this ability to direct massive traffic between people at a relative short notice. So that was the first bombshell. The second bombshell then happened when I arrived yesterday evening, because I thought I had my talk more or less prepared, was pretty confident. I was wearing my informatics hat. I knew there's probably no one in the audience who can contradict me or find out when I'm bullshitting. So I thought, that's great. I can finally try out some ideas that Elisa and I discussed when she was still in Edinburgh about how we can use big data research, create connections between IT law and environmental law. So I thought I'll start with a little project that we did on analysis of interconnections in legislation, regulatory density, and then I would talk about some of the things I know other people are working on, and there are some who are much further ahead than what we have been doing, really more as a side project, and I wanted to introduce that graph to you. And that's a brilliant graph, and it's a brilliant piece of research. There's a small problem with that. The quote of that is this, and the first name is obviously the next speaker. So at that point, I realized I was a little bit in trouble, having planned more or less to either preempt the talk of the next speaker or otherwise embarrass myself. How great were the chances of that happening? I'm sort of oscillating between law and technology for 20 years now. It never happened quite like that. So I tried to keep my composure during dinner, and then I made my excuses, as some noticed, before dessert was served, which is really unusual for me, and ran back to my hotel and started to regroup. So the talk that you are going to get is a little bit, at least, a result of the regrouping, but I think it will lead rather nicely to the second talk of this session. For me, one of the interesting things, and part of the reasons why I think I am here and why we had this discussions in Edinburgh, is that there ought to be a considerable overlap between research that is done on the IT law side, the law and technology side, the internet regulation side, and the environmental law side on the other hand, because both are concerned with data, both are concerned with information, both are in the interface between scientific disciplines and legal disciplines, and nonetheless that exchange is not systematic, at least as far as I can see. And definitely when we discussed this previously in Edinburgh, it was a new thing for us to have the IP group and or the IT group and the international law group trying to explore convergent interests. So for me, there's a sort of threefold interconnection here that is worth exploring. One is simply, what are the legal issues that are created by the use of IT for environmental protection? We are relying increasingly on IT systems to enforce environmental law, to monitor compliance, to increase our or decrease our footprint on the earth by optimizing production and things like that through IT. What are the legal issues in there? Well, there's also, it seems to me, a possibility to exchange conceptual questions, to ask, are there certain types of concepts that have been developed in either discipline that can make a useful contribution to the discussion in the other? So listened with great interest at the talk here by a previous speaker about non-Western conceptions of communal property, especially cultural inheritance and cultural knowledge, because one of the things I will try to do on Friday in Paris is to convince Facebook that they should think of their users as a community that collectively holds data, not in the sense of a classical IP right, because I don't think that gets us anywhere, but in a certain sense of data stewardship. So for me, that is one of the fields where there can be a positive exchange of ideas from the environmental law side to the governance of information in the IT side. And then finally, what was originally the center of this talk, the question of how can we use the data that we generate as lawyers and the new methods for data analysis to get a better understanding of the impact that law has on environmental regulation and on regulation in general. So there are three issues that are interconnected. And I want to start with the first one. Obviously, environmental science relies more than most other scientific disciplines on big data, and climate modeling is one of these prime examples, and also one of those where we know how easily things can go wrong, not so much in the modeling itself, but in the way it is communicated to the public, and how easily public trust is lost. And that is a discussion that we find in a very similar way also in IT law under the header of algorithmic governance. We are increasingly relying on automated decision-making in all fields of life, and increasingly we struggle, I think, politically to communicate the validity of these models to the citizenship and also allow the right type of scrutiny of these models. You might remember or might have heard a few weeks ago yet another big headline-grabbing event about big data-driven sentencing support systems in the United States that try to predict the chances of recidivism. They are based on a data model that is totally and utterly intransparent. No one knows what's going on there. It is owned privately, so as soon as lawyers try to cross-examine it in court, they were told, I know there's a trade secret and competition law concerns, so you're not allowed to even find out on which basis these decisions are made. And I think that problem, that on the one hand, modern governance relies increasingly on big data sets and the algorithms to analyze them and the formal models to make sense of them, but at the same time, increasing difficulties to explain them in a meaningful way is one of these big problems both fields share. In 2013, those of you who don't know that, people who were thinking along similar lines had a launch event of a network, relatively loose network called ICT4ER, Information and Computer Technology for Environmental Regulation. We met in Galway at that time. There's a website with some, I think, rather interesting resources. We are not as active as we had hoped to become in 2013. Life happened, as it so often does. But there is still a sort of nascent network of people who think that in this intersection between data science and ICT and environmental regulation, real gains can be made for our knowledge and understanding. At the time, I was talking in particular about the way in which IT law concerns itself with control over data, which is power, and the right and the duties to disseminate data and the restrictions to collect, copy, and access it. That is core IT law. But those of you who are environmental lawyers obviously know about things like breach notification duties, the duty to inform about environmental hazards and accidents. So quite a lot of modern regulatory tools rely also on giving access to information, controlling information flows. So from that perspective as well, there's a convergence between these interests. The examples I gave is this smart grid. the idea to dramatically reduce our environmental footprint through reduced energy consumption and through more efficient transport by combining the users of electricity, of energy, and the producers in much more efficient data-driven ways. So one typical example would be I drive with my car to the next recharging station. While I drive, I actually generate some energy. And then I can make a choice to either recharge my own car or feed that energy back into the grid and get some money for it. In order for that to happen, the charging station needs to know who I am to credit the right type of account. And that account is not any longer linked to my car, it's linked to my house because it's my home energy provider who is behind that. And at that point, IT law, in particular data protection lawyers, get very, very uneasy because what they realize is that while the economic and environmental benefit of this approach are undisputable, the amount of data that has to be exchanged to make it work is quite massive and increasingly difficult to control. So there are in this smart grid, when you ask the technology people, primarily flows of energy, which are not any longer following normal consumption patterns, but there are in parallel massive flows of personal data. Some of that potentially quite sensitive personal data, depending on how it is measured. That, for instance, is at least in one vision, a smart home where your energy consumption is analyzed all the time. You can get the data on your smartphone so that you can see, is there something running that shouldn't, and maybe I can switch it off remotely. But as a result of that, that's where the big discussion then comes in. Within specific time periods, a measurement will be taken about your home energy consumption. And depending on how sensitive this measurement is, whoever provides you that smart metering will find out quite a lot about you. They might find out if your coffee pot is on or your refrigerator is on. They might even find out which TV program you're watching because different TV stations have a subtly different energy profile. They might find out if people were in the flat while you were not around. So quite a lot of potentially sensitive data being collected in that effort to make more efficient use of our energy, and with that creating a potential conflict, at least, between data protection, IT law on the one hand, and environmental regulation and protection on the other. So what do people do? Well, one thing, and that's really where my normal research is located, they'd say, well, these things become too complicated to be done any longer manually. We have to create not just smart energy grids, we also have to create smart information grids to get the right type of balance between protection of privacy, protection of security for individuals, and at the same time, the environmental benefits and economic benefits that we are searching. So one project, for instance, is Smarter Privacy. That's run primarily by the Karlsruhe Institute for Technology. They essentially try to ensure that the data streams that are exchanged as part of these projects are law compliant by programming the relevant aspects of German data protection law into an expert system that assists the software developer, the guy who essentially develops the infrastructure for the smart grid, to ensure that they only allow information flows where that is legally permissible. And with that, ensure compliance by design. And I suppose a great contribution IT law has made in the last year to the theory of regulation is that emphasis on the importance of design solutions, that we are increasingly accepting that it is not any longer possible to do data protection, freedom of information, copyright in a manual, responsive way through a legal system, but rather that we design them directly into the information infrastructure. That is essentially how it then looks. You get a superimposed system. On the one system, you have energy flows. the energy, the electricity that flows to various users in the grid. Under the second system, you have the corresponding backflow of data between citizens, and the engineering infrastructure ensures that the right type of data and only the right type of data ends up where it is supposed to. Now, if we think in terms of global justice, that is for me the first part where things get potentially tricky, because that is quite expensive and that is difficult. And that is sometimes the more expensive and the more difficult part of building a responsible smart metering or smart grid environment than the actual physical engineering or electrical engineering. So the big danger that I see is that countries are going to take just the upper level, just the electricity exchange level, but do not at the same time also implement the data protection level that is so crucial to protect people. So you can easily see how a technology that on scientific grounds works extremely well, and for that reason alone will be very attractive to also implement in other megacities around the globe, can create potentially quite serious dangers for justice, for liberty, if that second level, the level of data protection that is isomorphic, that maps directly on the electrical exchange level, is not implemented at the same time. Not talking too long about that. Well, yes, to a certain extent, I want to. Where does environmental law come in? Oops, can I point? Is this a laser thingy? It's essentially there where it says permission or order by FDPA or other act. So essentially, the smart grid understands that in order to release data, at least personal data, to a receiver, there has to be a legal ground for this. The legal ground for this can be some other legal obligation. Some of these other legal obligations will come from environmental law. So in order for the smart grid to understand what type of data it is allowed to release, there also has to be built into the system some form of formal representation of at least some aspects of environmental law. And that is what essentially computational legal theory does, name of my chair, trying to turn human natural language legal provisions into something that can be executed by a computer program. And at that specific place, you can see how privacy by design and environmental law start to interact, because here there has to be some recognition that certain types of data can be shared, provided that there was the right legal authorization in place. At a level of complexity, remote sensing, again, something that is crucial for environmental monitoring, environmental enforcement, and suddenly you get data from foreign jurisdictions. You get some data that is collected subject to the law of outer space, which adds, as you can imagine, again, another level of complexity. You get different types of sensors with different types of sensitivity, and you get, again, another big set of data potentially flowing into these systems. And again, you have to ask yourself, what type of information do we want them to see? What type of information do we want them to pass on? So we extend the number of sensors that are available. The good thing with these is they are still sort of government run or professionally run, so at least they come with data quality assurance guarantees. Should have waited with that. Actually, that is the first. Connecting step. So you get lots of data. You try to make sense of that data. Doing this individually is not any longer possible because there's just too much of it. Making it open source and allow lots of people to update it and annotate it and add semantic value to it is one way of dealing with this. So suddenly you have data that is collected by remote sensors, quite a lot of it, but the way the computer system understands it depends on lots and lots of individuals donating a little bit of their time to add meaning, to add information to it. So you have suddenly data in your system where the meaning part, the component, doesn't any longer come from controlled sources, but from potentially crowdsourced large communities of users. And that obviously adds a significant level of uncertainty, of quality assurance problems. And if at the end of the day the algorithm is making a decision whether or not to release specific types of potentially sensitive data, we have a potential concern here, to put it mildly. Here we get that, again, elevated to another level of complexity. I don't know if you recognize that for what it is. It's an app that has been developed in China. It allows people to take a photograph of their environment and a reading of the pollution levels and to upload them to a centralized server to get a air pollution picture of China. It's done by citizens for other citizens. It's an entirely crowdsourced way of gathering information. From a data protection or generally a data engineering and IT perspective, you add another level of dangers here. You add dangers for the researchers. The Chinese do not really like these public display of pollution levels. They do find that, firstly, a reputation risk, but also potentially a strategic national security risk. So if you are participating in this, you are submitting yourself to a certain extent of risk. So we have to ask what type of computing infrastructure is appropriate for that, where should we host these servers. There is then the risk of other people that they might accidentally capture when they upload a photograph. So there's a risk for third parties. And then there's again the data assurance, data quality risk. Can this be manipulated? Can a city that wants to increase its property prices, for instance, send out lots and lots of people with lots and lots of smartphones on a really nice and clear day and take lots and lots of slightly modified and not quite accurate readings so that the impression is created that everything is much, much better than it's supposed to be? So as you add complexity into this, the task of the privacy engineer or the IT engineer gets more and more difficult. The benefits, the potential benefits for environmental justice increase, but at the same time, the hazards, if you think of it as an information infrastructure, also increase. Finally, just to throw that one in, robotics, agriculture is probably the field where the robotic revolution is the most advanced and the least talked about. Everyone talks about smart cars and killer robots. Killer robots are really popular. My students love to hear about killer robots. I always want to talk to them about automated cow milking machines because I had to earn my money for my studies milking cows. And I tell you, automated cow milking machines, robo-milkers are a brilliant idea. And the cows that I had the pleasure to milk I would totally agree with that assessment. It's really in everyone's interest. Quite substantial amount of precision agriculture, which will be much, much more environmentally friendly than what we have at the moment, will again rely on the robotic revolution. But here we add the opposite from the crowdsourced data collectors. Here we add automated data collectors that simply work through an algorithm. And can we be sure that the data that they collect is the right data? That they were putting the sensors in the right place, doing the right thing with them. So by automatizing data collection and evaluation, we add another level of complexity that all feeds into this big data assembly. Different sources, all coming in real time, different degrees of accuracy, different degrees of human control, and from a legal perspective, we somehow have to make sense of them. That is one of the ways in which my team tries to make sense of them, and we are using something from system theory. Rather old ideas from the 1970s used to describe complex engineering systems and machinery, Petri networks, and we can use them to a certain extent to model the flow of data and information within networks and the corresponding flow of whatever we are interested in, for instance, energy or chemicals or whatever. So if you think about law as a complex interconnected system with the environment, we can think of the energy flows and the data flows, the legal flows as interconnected, and Petri networks are one relatively straightforward way of trying simply to understand what is connected here with what, where are the data flows, where are the things we ought to be concerned about. And we can think of law as essentially the transistors in that system, the things that allow sometimes information to go through and sometimes not to go through, depending on the program that they adhere to. Now, the problem with that is, even though they are rather intuitive and they help us to make sense of these complex systems, they simplify them to such a level that we can ask ourselves, is that a simplification that is a distortion? Is that still the reality in these hyper-complex systems like a smart city, for instance? Does this measure or does this describe the data exchange accurately? Because essentially, they are still done manually. They are done by someone, by a human expert who starts to develop these systems a priori and thinks about the information and data flows. Whereas in reality, these systems are organically growing. They are to a certain extent unpredictable. They might acquire unexpected properties simply through the degree of their interconnectedness. So we might need a different metaphor here and a different approach. This is the old engineering. This is engineering 1970s, a nuclear power station. Complex on one level, but still controlled, still understood, still explicitly deterministic in what we put in. And the more complex cyber-physical systems of today we are dealing with might not any longer have these properties. So some people start, and that's where we can touch briefly on the conceptual exchange, also of information ecology. And information ecology is a system of people, practices, values, and technologies in a particular local environment, or as Luciano Floridi calls it, the infosphere. And that now takes explicitly concepts and ideas from environmental science and applies it to information science, thinking of information as something that happens in a specific type of environment, creating an infosphere. In these infospheres, there are predators and even apex predators who can expunge certain types of data and control it. There are grazers that draw lots of data to them. So we might be able to use environmental science as a guideline on how to model information flows rather than the old 1970s level engineering science. And with that, we finally get to big data. And I'm almost finished and capable of passing on the baton, because if that analogy is right, if we should think of critical information flows in cyber-physical systems, including environmental cyber-physical systems, as a type of biological environment and take our inspiration from there, then we can use the methods, the algorithms to mine data also to describe these environments. Now that is one example I just wanted to bring in because I knew we had a session about comparative law. That is something a student of mine did, comparing citation patterns in Austrian and common law jurisdictions. Just taking not really big data. Lawyers think of that as big data. Data scientists don't think of that of big data. 99.5% of the time when a lawyer speaks about big data, they mean middle-sized data. Not quite as small data as it used to be data, but that is not really a catchy phrase, but that is essentially what it is. So we used a few thousand court decisions here with, something you could still comfortably put on my disk, and that is not big data. But what we looked at was whether there were organic citation patterns emerging. And we had a hypothesis. Our hypothesis was that civil law countries and common law countries would have very different citation patterns for precedent cases, simply because one has a doctrine of binding precedent and the other doesn't. So we should expect, or we would have expected, clustering in common law countries and relatively hierarchical or flat system in civil law countries. We also, and that brings the global justice and comparative dimension in, we anticipated that common law systems would have relatively less references to foreign cases, because the idea, after all, of the common law is that it is the law of the local community and reflects common community values. But on the other hand, we expected continental systems to refer quite a lot to foreign jurisdictions, because there we talk about the science of law, Rechtswissenschaft, says on my certificate. And science shouldn't have national borders, shouldn't it? Something works or it doesn't work. So these were our two hypotheses, and they were both wrong. which I found quite exciting. We found that the citation patterns in common law systems and continental systems strongly converged, virtually identical. They both adhere to precedent pretty much in the same way. And as far as the influx of foreign legal ideas is concerned, common law systems are much more open to foreign law than continental systems, if you look at patterns of citation, which we found interesting and worth thinking about. We can then, this was a small data thing, but we can put that onto a big data level. That is essentially, some of you might recognize it, again, it made the news, using Twitter to predict the outbreak of flu. Simply by looking at Twitter data, people tweeting, oh, I'm really feeling hot and bothered today, and my neck hurts, and not really doing a diagnosis, but from that being able to model the spread of the disease through the local population. And we can do the same with opinions. And we were speaking about transplants earlier on and legal formants. We can think of them like viruses that infect a host system and then try to find out how exactly is it that they spread. I mean, Alan Watson talks about legal transplants. He takes a metaphor from medicine, and I think he does it with a reason. This is essentially the same sort of thinking, and here we can start to think about the ways in which we can use big data analysis to find out if some of these intuitions are right. How exactly do borrowed concepts spread through a recipient legal system? How is international law received? Can we look at simply self-organizing patterns of citation and see if some of our theories are right? Here, and that is the slide you remember from the beginning, which tells you you're almost there. That is one of the things we try to do for this. We try to find a way to measure regulatory density. Are there fields that are more densely regulated than others? What happens if you remove one piece of legislation? Are there ripple effects through the entire legal system? So we did a little bit of essentially statistical analysis, relatively simple natural language processing for Estonian law. It's not for environmental law. What you see in the bottom is Estonian copyright law, and we wanted to see how it is connected to the rest. It's relatively separated. But the idea essentially was, can we get a measure of the degree in which different types of regulation coexist, interact with each other, strengthening one might weaken another? Are there connections that are maybe unexpected, organically emerging in the system? And we went so far, but essentially it's a syntactic system. It looks at words and word similarity. So if you have the word employment in copyright law, as a rule that sets normally it's the employer that holds in copyright law, and you have it obviously in employment law, then it would give us a link simply because the word is the same. But if they use different words for the same concept, we would already struggle, because for that you need something else. You need an ontology. And some people, oh, I'm pretty certain I had your slide in the last one. Sorry, I should have gone back more or less right to the beginning of my talk, because when we add semantics, understanding of these concepts, if we superimpose a legal ontology, then we get something not as relatively simple as that, but something as complex and fascinating and interesting as that. And with that, I'm happy to pass on the speaker's desk to the next speaker. Thank you.